SJC-11900, Commonwealth v. Robert McWilliams.
What's that case? I think it's, which one do you think? I bet it's first line. I bet it's on
Good morning, Mr. St. Lawrence.
Chief Justice Gantz, Associate Justices, may it please the court, Timothy St. Lawrence for Robert McWilliams. This court has recognized the substantial scientific research establishing that jurors find eyewitness identification evidence unusually powerful. They're unduly receptive to it, and they trust it implicitly, especially where the witness's confidence in his or her identification is high. In this case, the evidence showed that the bank teller's identification, she was sure, totally positive, 1,000%.
Is that she testified to that?
She testified to some of these, and then some of them were from, like,
I know she said, I just didn't know if that actually was put before the jury.
Yes, this was all evidence put before the jury, that either she had told someone she was 1,000% positive, or she herself said, I'm positively certain it was him.
Well, maybe she was. I mean, he held her up. He wasn't wearing a mask or anything. It was in a bank.
Yeah,
right?
He did have a mask on.
He had a mask on.
He had a ski mask on. When,
Took it off, of course. And
as he was leaving, he took it off, and she saw the back of his head.
so did he come into the bank with the mask on and a gun out, or did he get up to the teller's?
He had from what I understand, he came into the bank with the mask on.
Oh.
So for you to prevail, though, on this, you'd have to show that you would have likely prevailed on a motion under Commonwealth versus Jones.
Right, that's the, I agree, that's the issue.
Which doesn't happen that often. So why would it happen here? Why would this be a case sufficiently compelling for you to get suppression under Jones?
Well, I think the circumstances of this identification were especially suggestive, so as to be unfair, in that the way that it took place was there was a man who was out smoking a cigarette on July 7th. He noticed a man also outside the bank. He didn't see his face. He went back inside. He comes back out later and finds out there was a bank robbery, and people are talking about what the person looked like. And so his mind jumps to this person he saw earlier that day. Now, 3 weeks later, he's outside again, and he notices a man that he thinks is similar to the man he saw. At this point, he has no idea if that's the person or not, but he's kind of making jumps that this could be the person that robbed the bank on the 7th, 3 weeks prior. So he takes a photograph with his iPhone, goes into the bank and shows that photograph to the bank teller who was held up and asked her, is this the same man?
Well, assume that that is highly suggestive, as is required under the case that was just cited. Why isn't this necessary? I mean, you also have to show that it was unnecessary. It could have been necessary in this case because they were worried that he was going to do it again.
Sure.
So in that situation, wouldn't it be appropriate for the teller to look at the guy and see, well, yeah, that's the same guy, so let's call the police here?
It was absolutely a reasonable thing to do, in my view. I don't think I could argue that with a public safety issue like this, that this
So
was...
where does that leave
But
you
I don't
then?
think Jones talks to necessity. I think it talks to, it's so especially suggestive, regardless of whether it was necessary or not. It's unreliable because it's so suggestive. So it's not going to that issue, I would suggest to the court. It's going to, it's unreliable whether there was a public safety issue or whether there wasn't. It's still the same unreliable evidence, and for that reason, it's tainted. Now, under Jones, if the Commonwealth can show that the bank teller had an independent source, if she saw the person for an extended period of time, the man didn't have a mask on potentially, and she was able to have an independent source for her identification, then she could identify at trial.
But it wasn't that, was the picture that, or the cell phone, whatever it was, picture that was shown to the bank teller, was it of the back of the person's head?
That's my understanding from reading the transcript.
So what do we have here? We have essentially a show up or a lineup, and all the people who are facing the witness are asked to turn around and say, do you recognize the back of any of these heads? Is that basically what the identification was?
And it's even a little weirder than that, because
Was that what the Commonwealth's case was based on?
there was some other circumstantial evidence that he was.
Well, didn't she, well, 3 weeks later, though, he was sitting at the table and she looked at his face, right?
Well, this is, okay, yes. So he goes in initially, shows the iPhone picture. It's the back of his head. She says, well, it could be, but this guy has long dreadlocks. The man in the robbery had short hair. And he says, well, I think it's a wig he's wearing. And she says, okay, well, he says, he's outside. Why don't we go take a look? So then they go up to the window of the bank. She's becoming agitated at this point. She's becoming nervous again. And they look outside, and he's seated 20 to 25 feet outside the bank with the wig and sunglasses on. And at that point, she says, yes, that's him, based on his skin color, and I'm not sure what else exactly, but
Build?
His
Some
build.
His
description
build,
about his being not,
from what I understand, he's
tall,
sitting down.
wide
But yeah, I
shoulder.
guess his build and I guess his height, if she could tell.
How did the prosecutor deal with that in closing argument? That this, I mean,
The prosecutor-
the strength of that identification of the back of a person's head.
Well, it was the back of the person's head to begin with, and then I guess
And then she recognized him by his face?
by the front view.
Well, she never saw his front.
No, she did see his face.
Yes, she did.
When he took his mask off, she testified that she saw his face. Correct?
Saw his face? I thought it was she
His
saw
head
the
and
back
his
of
face.
his
It's right
head.
here in your brief, actually.
Okay.
I'm
Well,
quoting your brief.
She saw his face later anyway, because she saw him get arrested, and they took the wig off. And she said, well, now he's taken all that stuff off, yeah, I'm really sure it's him.
Right.
But,
That same
but
day.
did she ever see his face on the day of the robbery?
Justice Cordy is telling me that she did.
He's saying that you wrote it in your brief.
I haven't read the transcript,
So, I mean, I don't have time to check that right now. If she did, it was very brief.
probably.
As he's leaving, maybe, I thought, and I stand corrected, I'm not going to argue with myself, I guess, but.
If I can take it back to Justice Hines's question, if this particular person had, instead of doing what he did, went to a police officer and said, I think that's the guy who robbed that bank 3 weeks ago, and the police officer then used that as reasonable suspicion for a stop, and then asked the tellers to come out and did a show-up of him, that would be fine. Would it not?
I think that would be fine.
So why is it not fine? Because
In here.
they did it this way. Why is it?
Well, she's getting a lot of-
Why is Jones broader than if a police officer had been involved?
Here, she's getting a lot of confirming feedback
can I just go
from,
back to her for just a second, because I'm afraid we're going to go on the, I'm pretty sure that you're talking about the teller.
yes.
You're not talking about the assistant manager who got a look briefly at his face. She only
no.
saw the bald head?
The teller saw the bald head
Back.
leaving.
Yeah, okay.
Okay.
All right,
And
thank
then
you.
the assistant manager must have saw the face briefly.
So
That's
now we're just
Sansarin.
talking about the teller and her
I'm talking
ID.
about El Hafadai,
Right.
who testifies that Sansarin at trial isn't able to make a
Right.
in-court ID, but El Hafadai is.
Right.
based on this suggestive.
Sorry to interrupt, I just was.
Sure.
Thought we needed to make sure that we knew what the original view was, if any.
Right, the original view is him masked. It's 30 to 40 seconds. There's a gun in play. She's very stressed out.
On his way out, he
On
takes
his
off
way
his
out, he
ski mask,
takes it
which
off.
allowed Ms. Al-Hafidi to notice he had an almost shaved head, and then he.
Right.
Okay,
So,
thank
but-
you, sorry.
Could you turn to your argument about the statement that he made to the police in the jail cell, and then the subsequent, this was after the 6-hour safe harbor period in Rosario?
Okay, and the issue, I guess, in this case would be, because I think it was a volunteered statement, he called the police officer up to his cell and wanted to talk. He thought the police officer was nice to him, and he wanted to give him his bike, and he wanted the police officer also to get him his prescription eyeglasses because he was going to need them. So he tells the officer that I rode the bike today. I left it in the garage next to the bank. Will you go retrieve it, and you can keep it, and you'll give me my prescription sunglasses? Now, why this kind of becomes important is because then the officer goes to the garage, gets surveillance from the 7th, the robbery on the 7th, and about a minute and a half after the robbery, the surveillance of the garage shows a man leaving on a bike, a black man. So the theory of the Commonwealth is this is the same guy on the 26th as it was on the 7th. Mode of transportation is the same. Although the bike on the video was different, the prosecutor said, well, he might have taken the bike rack off and, you know, but that was the theory why that was important.
So you're saying it was, you, in order for this to make a difference, you'd have to figure out a way to get the video suppressed, not just the statement suppressed.
Right, so it would have to be on a
That's sort of
secondary
pushing it, right?
evidence.
It's fruit, that's what
It's
you're saying.
fruit, and I understand, I guess the case I would point to is not directly on point, would be the Martin case that's cited in my brief, where it was a Miranda violation, an unwarned statement, and the fruit was suppressed in that case. And I would suggest
but why should-
Rosario. I'm
Yeah,
sorry.
go ahead.
I would just suggest that Rosario and Miranda are both prophylactic rules intended to
But he-
protect constitutional rights.
But he wasn't questioned, though,
He wasn't questioned.
and he just blurted it out.
He initiated the conversation, absolutely.
And they
then-
didn't ask him any questions?
No, there was a conversation, so I think I'd have to concede that there wasn't any questions. It wasn't interrogation. It was him,
The police
Calling the
officer was trying to accommodate him.
right.
You're basically, I think, you're taking the position that Chief Justice Ireland did in his concurring opinion
Right.
in Fortunato.
That's right, that it's
Anything
any
after 6
statement.
hours, anything after 6 hours.
Because here, the Commonwealth, he was
why
arrested
should
and
we-
booked by 1:30.
But why should we do that? You were saying that Miranda and Rosario are both prophylactic measures, but what did the police officer do wrong? I mean, what are we trying to?
I think the
protect.
misconduct here is that he was booked at 1:30 in the afternoon.
Yeah,
and he
it's more than
wasn't-
6 hours.
Right, so they had an opportunity at that point to arraign him or to get a waiver. They didn't.
So they shouldn't talk to him at all without getting a waiver after 6 hours for any purpose? Once 6
I would-
hours passed, you're saying Rosario, on your reading of this, would require the police simply to get a waiver, otherwise have
Waiver in order to
absolutely,
talk to the defendant.
about anything, including the defendant's need to use the facilities?
Yeah. I mean, say he says, can you take me to the bathroom? And on the way to the bathroom, he says, just blurts out, you know, I just committed an armed robbery of a bank. That's all he says. Can't use that.
Under Chief Justice Ireland's reading of Rosario, and which I agree with, is any statements, And therefore, if the police want to avoid that, they could have easily, in this case, by arraigning him that day or by getting a waiver at some point.
So no contact without a waiver is the rule.
Unless the police are willing to realize that anything he says is not going to be used
So the
against
police,
him.
he says to the police officer from his jail cell, could you get me a sandwich? And by the way, could you make it sardines? And it turns out that the bank robber left half a sardine sandwich in the entrance to the bank. That goes out. That's not admissible.
If it's after the 6 hours, I would say because it's a bright line rule, sometimes it's going to be overprotective of defendants' rights, but sometimes it's going to be underprotective that wouldn't be inadmissible.
Can I ask you this question? You have a variety of arguments of ineffective assistance of counsel. What would you concede this was a very strong? I mean, you say it's not an overwhelming case. Tell me what would have been different? I mean, it just seems to me like it's a very strong case we're dealing with.
Right. I just go back to the point about how jurors receive the type of eyewitness identification that was in this case. That was the only eyewitness identification of him as the perpetrator of the robbery. So I think that was potentially very strong in the eyes of the jury. This court has recognized that instructions on and cross-examination don't necessarily counter the effect that a positive ID can have. And then when you get into some of the circumstantial evidence, if you scrutinize it, a lot of it, like I said, with the bike was different. The gun was potentially different on the two occasions. It's different clothing.
Long sleeve
So
shirt.
there are some, there's circumstantial evidence, obviously, that it's the same guy, but I think if you take out the ID and start looking at that evidence more closely, that it may provide a reasonable doubt and that the verdict may have been different.
All right, thank you.
Thank you.
Good morning. May it please the court, Crystal Lyons, Assistant District Attorney for Middlesex, on behalf of the Commonwealth.
Can I ask you about the attempt? How do you get there?
On the attempt? Yes, Your Honor. With the attempt, this court in Bell has recognized that a defendant need not be at the scene of the crime and that some steps of preparation may be enough. And it looked at, what you want to look at is the gravity of the crime, the seriousness of any danger posed, and the uncertainty of the result. Now, if you look here...
But let me ask you this. If he hadn't robbed the bank 2 weeks before, and all you had was his being in front of the bank with a wig on and a gun, of course, in his bag, would that have been enough?
I do think so, but I don't think that you can exclude the fact that he robbed the bank before, because that evidence would be admissible as modus operandi. It's such similar circumstances to the previous robbery. And this court in Austin and in Helfand has said that type of evidence is admissible. So if you look at what we have here, we have an armed robbery, which is a life felony. So it's very serious crime and very serious danger. The steps that he's taken, he's 20 feet outside of the bank.
But I mean, just like, I can't remember, is Bell the one that was in the parking lot? And
Yes. Yes, Your Honor.
I mean, he's sitting there. He could have walked away. I mean,
Your Honor, where he's engaging in similar casing behavior as he did on the previous time. I know my brother said in his...
he's standing against the thing looking around.
It's at the same time of day. Mr. Gregorian's testimony, who was the other civilian employee, had seen him engaging in similar type of behavior before, looking towards what can be inferred as a time when the bank would be cleared. The first robbery, there was only one customer in the bank, and at that time he had entered through the side entrance and not the front entrance. My brother says in his brief that Mr. McWilliams still had yet to arm and disguise himself, but that's simply not true. He had already armed himself, he had the gun with him, and he had already disguised himself. He was wearing long sleeves, long pants on a hot July afternoon to cover all of his tattoos. He was already in a dreadlock wig, which would cover all of his tattoos around on his scalp and all around the front. He had already had sunglasses on. The only remaining disguise that he had left was another beard and taking out the gun from the bag, both of which would have been incredibly conspicuous and would have drawn attention to himself, whereas the disguising that he had done so far did not draw unnecessary attention to himself. He had only been at the bank for moments before the officers arrested him. They said that they arrived within 1 minute of getting that phone call.
But is it so close to the consummation of the crime that it amounts to an attempt? I mean, what if he were just, why isn't it consistent with just casing out the bank? Yeah.
Here, he has already disguised himself. He has already armed himself. He's in a very similar circumstances where he was July 7th.
Isn't that just to prevent anybody who might have seen him earlier from recognizing him as the same person with the bald head the last time?
However, in the July 7th robbery, as you see, the video surveillance showed that he was only in the bank for 40 seconds. I don't think that we want to set up a situation with a dangerous armed robbery of a bank where the officers cannot stop an attempt until you actually enter the bank and draw a weapon, that they only have a 40-second window of opportunity.
But he had
a
a different wig on, didn't he?
He was wearing a ski mask on the first time, and he was wearing dreadlocks on the second time. He was wearing very similar clothing, again, sports-type clothing and the long sleeves, the ski mask and the wig both, to disguise all of his tattoos.
Was there a mask?
Evidence that he had some connection to this area. I didn't read the trial transcript, but was he a Cambridge resident? Did he work in the area?
No, Your Honor, he did not.
That was established by the evidence in the case?
It was established by his video interrogation. I don't believe that there was evidence introduced in the trial as to where Mr. McWilliams lived.
What was the defense to the attempt?
The defense to the attempt was that he was only getting fresh air and that it was essentially a misidentification.
If Van Bell is not, I mean, Van Bell, he was in the car en route to sexually assault, what, a 3-year-old? If that's not an assault, how is this an assault?
I think in Bell, you really looked at all the steps that he needed to be done first. There was no child even present at that time. Whereas here, he's 20 feet outside of the bank. It only takes a matter of seconds to walk in it. It's the same time of day. The first robbery.
Attempted armed robbery?
Yes, Your Honor. He had the gun with him. I mean, yes, it turned out to be a pellet gun, but he had that gun with him in his possession, already in disguise, already with sunglasses. The teller, not jumping ahead to the identification, but just for purposes of timing here, was looking at the picture on the iPhone when he walked by in front of the bank and sat down. Within, as I said, within a minute after calling police immediately then, the police had arrived on the scene. So he was really only at the bank for moments before he was arrested. So there's just nothing in this case to show that he'd had any kind of change of action, any change of heart, any withdrawing from his clear purpose to rob the bank. Turning to the identification question, if there are no further questions on the attempt, I think it's helpful to look at my brother's brief. On page 24, note 5, he actually separates out the individual identifications here, being the identification that he would like to be suppressed, being the identification on the cell phone, the walk-by identification, the identification that the teller makes after his arrest, and his in-court identification. I think as Chief Justice Gantz was asking about regarding if this had been a show-up procedure, if she had telephoned police and said, I recognize this individual, there is actually a case law directly on that point, which is this court's case in Walker at 421 Mass 90. And that case was very similar, where you had an individual who was a manager at a Dunkin' Donuts, and there was an armed robbery. A few weeks later, she was at a different Dunkin' Donuts. Another employee directed her attention to an individual at that store and said, you know, look at this guy. She then looked at that individual, recognized him as the same individual who had robbed her before, and called police. Then there was another show-up ID once police arrived.
Yeah, but here, you have, okay, so you have the photo, but then, you know, right after it, you've got you get her seeing him out the window, the police come, they take off the, I mean, it's a series of police arrest him, it's very hard to separate out these things so that by the time she gets to trial, and is talking about 1,000% sure, she's had all these different suggestive experiences happen.
I don't think that's true, Your Honor, where when you look at what the description of Mr. McWilliams was, it was strong and it was consistent and it was detailed the entire time, not just by the bank teller, but by the other witnesses, by Mr. Gregorians, who was the civilian witness, by the customer in the store, by the bank manager. And in Walker, the court distinguished between a chance encounter and something that was suggestive. And here, the defendant himself wholly controlled.
They didn't arrest him in front of the, I mean, she testified at trial. What I'm trying to say is, by the time she gets to trial, she just didn't come from having looked at the picture.
No, Your Honor, and the picture again was on a very small iPhone. So she's looking at a picture this big, 3 inches big, of the back of Mr. McWilliams with a wig on. So
Also talking with, is it Mr. Gregorians?
she is talking.
Now, if the police had spoken with her in that way, wouldn't that be problematic?
I don't believe so, because this court in Austin, and as well, I'm sorry, there's another case I cited in my brief too, where again you have some ambivalence with the individual looking at it. There's some back and forth saying,
Austin is way before the eyewitness study groups thing.
yes, Your Honor, but it's, again, the same thing of what she was indicating, what the teller was indicating, was a little bit of ambivalence, saying, I'm not sure yet because of this wig. There isn't, it's not as clear what happened exactly in the circumstances, but she does say that, as she's saying, I'm not sure because of his wig, is the exact moment when Mr. McWilliams walks by her, and then she immediately has the in-view person of him. That is a chance encounter under Walker and something that is wholly controlled by the defendant in this situation. There is nothing, no police action, but no civilian action either that would arrange for that occurrence.
How did the prosecutor deal with the bank teller's identification of the defendant in his closing argument? And in particular, did he say that she was 1,000% sure that this was the guy and she was an eyewitness identification? Or I mean that she had a solid identification? And did he compare, and how did her identification fit in relation to other people's identification of him? Was she the primary ID witness?
Her identification was obviously important to the Commonwealth, but it by far was not the only identification witness. Mr. Gregorians also identified Mr. McWilliams in court. There was also the customer's description of him, the manager's description of him. They did not identify him in court, but their description of him was also very similar, very consistent, and as well as surveillance pictures of Mr. McWilliams during the July 7th robbery were admitted, and which the jury had the ability to see.
From the garage or from the bank?
From the bank. So there were a series of photo surveillance from the July 7th robbery that were also admitted.
Showing his face after he took his mask off? Or no? Because
Or
they're
just walking out of the bank?
I'm unsure of that. I know that there were several photos identified and admitted at trial at various points. I can't say for sure whether they were just of there at the teller or at the ATM. Several of them were admitted through the teller when she said that, yes, that is the individual that robbed me, and that's what he looked like at that time. But again, if you look here at what the Commonwealth's evidence is, even if you were to say that Ms. Alfidi, the teller's, that picture identification was unnecessarily suggestive, the chance encounter with Mr. McWilliams walking by himself should not be, particularly where, yes, she did see him arrested, but there was a crime in progress at that point. And that's certainly not something that would be unnecessarily suggestive if,
Crime, the attempted robbery?
attempted robbery, yeah. They knew that he had a gun, they immediately saw the gun. The police needed to take tactics to make sure that he was not further armed or in danger. And I would say in similar circumstances, any crime in progress, if an individual calls for a crime in progress, they may see the police arrest that person who is a danger to them, but that does not make then their subsequent ID unnecessarily suggestive. And furthermore, even if all of those identifications by Ms. Halfidi were to be suppressed, I don't think it would make a difference in this case, where she would still be able to testify as to her memory of what the description of the robber was on July 7th, which was very detailed.
But she did make an in-court ID, didn't she?
She did make an in-court ID, but even if that were excluded, she would still be able to testify based on her memory of what Mr. McWilliams looked like on July 7th, which, again, was very detailed. It was his build, his height, his weight, his gait, so the manner of him walking. There was that he had a closed-shaved haircut, that his race, and that he was dark-skinned. I mean, it was a very detailed description that was consistent
So with
across.
respect to that, the video from the bank on July 7th, so I take it from what you're saying that her description of him would have been confirmed by what the jury could see?
Yes, Your Honor.
That's
They
what
had
you're saying.
surveillance of in the bank, and they had the testimony from Mr. Gregorians, including the in-court ID, and which has not been challenged, because similarly, it was a chance encounter controlled by Mr. McWilliams himself. Turning to the question of the volunteered and unsolicited statements of Mr. McWilliams, preliminarily, the court need not reach the question of whether or not volunteered unsolicited statements should be suppressed outside of the 6-hour period because of the posture in this case. It's a case that's arising on an ineffective assistance of counsel, and counsel's performance would be measured at the time when the decisions were being made. At that time, which predated Fortunato, and obviously still to this day, there is no case law that says that volunteered unsolicited statements outside of a
it was-
6-hour period should be suppressed. And so,
Can't say, I mean, obviously, there are people who read the rule as a bright-line rule that said 6 hours. So I mean, yes, there wasn't a case saying that, but it's hardly that it wasn't a very open question.
but this court in Mahar has said that counsel is not ineffective for not anticipating changes in the law or not making decisions
No, I'm
based.
just,
So what's your view on the merits of the Rosario issue? Should it apply to all statements or just results of interrogation?
I do believe that Rosario is limited to police questioning and that there are other methods for protecting statements that are outside that 6-hour window without police questioning. First and foremost is Fortunato, which is, this court showed a tough analysis in really looking at police's interactions to see if it was questioning or the effect of questioning. And secondarily would be the voluntariness of those statements apart from the fact of their volunteered nature. We have a very robust jurisprudence on the voluntariness, so that if there were some coercive circumstances in a case-by-case analysis that would take this outside of the inherent custody situation, then the court can look and see if those statements were nonetheless voluntary.
All right, thank you.
Thank you.
And we'll take our morning break.